My fourth mantra of legal user experience is win on the papers. And this is a true lodestar or a north star for highly effective advocates, the way they consider everything that they do in their law practice or in their personal life. Sun Tzu wrote of winning when it is easy to win. He would write that the greatest warriors of the time were unknown. They were unknown because they won when it was easy to win. There's an old fable of a family of surgeons and healers at the time, and they were asked who the best known surgeon is. They said, well, it's not us because we serve and heal before there's a need for invasive surgery and procedure. And this sort of goes to the idea that if you need to try a case to verdict, or if you need to take something to its ultimate conclusion, you really haven't won much of anything, or whatever victory that you did accomplish is offset by a lot of effort, money, uncertainty, time, etc. Winning at trial is hard. It's probably the biggest lesson I've learned from having tried over 30 juries to verdict. It's not just that it's unpredictable and uncertain, it's that it takes a lot of time. You lose your schedule. Whatever the judge's trial order is, you need to follow. You need to pull a jury down. You need to get 12 plus 2 in the box, or whatever it is in your jurisdiction with your case. You're roping real people from the community into your problem. And if this takes more than a couple of days or weeks, and all you're talking about is a little bit of money, you're not really talking about securing a victory. Of course, there are times when you must try a case. You're charged with serious crimes, for example, and you can't otherwise get the charges dropped. Or if you're seriously injured and the insurance company's taken a position against you that would not allow you to achieve full and fair compensation. Jury consultants are just about a dime a dozen, and they offer insight for a very high premium on the thinking of jurors. And they'll go and they'll watch the jurors and they'll apply their body of knowledge and work. And a lot of that I think is valuable. But what I find fascinating is that lawyers very rarely focus on our language, the English language. The English language is, I think of as a shoe print of a major portion of human thinking. Like, think about all the thoughts that human beings have ever had. And then think about how many of those thoughts occurred using the English language as the medium or as the method for having those thoughts. The English language, Professor Gardner states, is our sole arsenal. He states that it's our greatest legacy. I think that's a nice ideal. I'm not sure that I totally agree. But nonetheless, why focus on what a jury might consider when you're presenting your case to them and pay all that money and time for that, when if you focus your resources and time on our language and on winning on the papers, that's what this mantra gets at here. Winning when it's easy to win. That's how the effective advocates think. That's how the effective advocates act. And from this, there's a couple of rules or possible heuristics to consider to make sure you're doing this right. One practice that very skilled advocates do is they'll never request oral argument. They'll never do it. They'll watch as their opponents have to plead with the judge for oral argument. Well, Your Honor, we must address X, Y, or Z point. And especially this is effective if you practice like an everyday lawyer in front of like everyday judges who maybe aren't extremely experienced or maybe don't have lifetime appointments on a federal bench or otherwise possibly a little bit unsure of themselves. By you saying, Your Honor, we don't need oral argument, everything you need is in our papers, you're empowering the judge to really take command of their docket and not deal with just another round of nonsense oral argument. I came across this idea this way from a guy named David Skolansky. He thinks very highly of himself. He's a poker player. Wrote a book called The Theory of Poker, which I found very influential maybe 20 years ago now. Maybe more than 20 years ago, as a matter of fact. But he's a strategist and a thinker. And so what he talked about is, imagine a game of chicken where you have like one car and another car and they just go head to head and the car that peels out first loses. But if nobody peels out, they're going to go, crash head on. Okay, so imagine you're lined up ready to go. Okay, now you're here. All right, now you take your steering wheel out and you throw it out of your car in a way that the other driver sees. 3, 2, 1, go. What's this guy going to do? You've guaranteed victory. The other guy's going to leave, and you force the hand, you force the issue. Now, we're not talking about some theoretical game of chicken. We're talking about the practice of law. And if you do your job well, you'll win on the papers. You'll present the court with everything needed to rule decisively in your favor. No hearing necessary. So, point number one, subpoint number one, never request oral argument. A second point is always know the cost associated with not having your page limits. I believe and I teach and I consult that you can have the page limits of everything, every issue, at every stage, no matter what. But the real deeper meaning of this idea is that there's a cost associated with exceeding half your page limits. And I want to be clear, I'm not talking about requesting additional page limits in your briefing in excess of what your jurisdiction allows. That's something you should never do. That is just inexcusable. That is a loss. No lawyer who respects themselves requests in excess of page limits. If they do, they're just doing it wrong. The point, though, is to figure out the cost associated with exceeding half of your page limits. And in a previous video, I discussed a technique where you just open up a new Word document, open the bullet function, and just start listing your points. If you're responding, list the cases your opponent raises in a note as to why what value or significance it has in the argument and why they did it. And as you flesh it out and you organize and you put your sentences and then paragraphs and then sections together, you'll start to come up on that halfway point, and you'll start to sense the cost of exceeding that. Now, here's why this is significant, okay? When you have a blank document, every letter you type in there has immense value because it's the only letters on the page. It's the only sentence on the page. It's the only bullet points on the page, which become the only paragraph, section, etc. The more you put in, the less value all the words have. Because there's just more words and more pages, less attention can be given by the reader to whatever is said by those particular words. And so it's important to start over and start fresh and really flesh out. And you'll realize that there's a cost. And that cost is invariably like the legalese, beginning with the now comes and pursuant to this rule and then blah, 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 the whole like half a page, introduction. Lawyers will always say, well, I can never even come under my page limits, let alone have them, because I've got all this nonsense I got to put in there. It's a cost. And the really effective advocates know the cost. And when you know the cost, and you know that the cost is stuff that's not good, it's excess verbiage and editorialization, it's case law in support that's not needed, it's argument by analogy that's not needed for some of the most basic principles. And there's some really good works out there. Garner's, The Winning Brief is probably the standard for, forensic legal writing in this context, talking about a simple point of law, a more complicated point of law, and then like a novel or a, one that requires some analysis. And you got to get a sense of like when just little points will do, when there needs to be fleshed out, etc., and so forth. You're trying to like really piss your opponent off, maybe you dump a string cite and force them to do all this work, but understand what you're doing is not helping your cause, it's hurting it. It's injecting uncertainty into the mind of the user, of your judge, or if you're in arbitration. You're forcing them to consider more things. And these cases are like never on all fours with you. You're arguing by analogy. And many times you need to, many times it's very appropriate, but there's a lot of times when it's not. So these are the costs associated with not having your page limits. When you start to get a better sense of what these costs are, you start to understand how you really can never afford to not have your page limit. Or stated differently, you'll understand when you exceed your page limit, you'll understand why. You'll understand what you're pulling out and what you're putting in. And your briefs will become more dense. They won't actually feel heavier. You're not even going to print them out ever these days, but they'll be more dense. Every word written will be read because your user will know, hey, there's probably some important stuff in there. And one way where you'll know for sure that you're well on your way to winning on the papers is when you start getting requests from clerks for your Word documents or your briefs in Word document. That's a dynamic that will make you, certain that you're going to get an order in your favor. But even before that, if you can get your opponents to agree to abandon a case or to abandon a claim because there's just no way that they're going to win, that's the ultimate victory. I actually had the pleasure of this happening when I was in my second year of practice. I began at a trial firm, what I believe was probably the most active trial firm in the country. The firm no longer exists. We represented non-standard auto insurers that offered state minimum policies. We represented them on flat fees. So we take a case from pleadings through post-trial motion practice for a flat fee of a few $1,000s or whatever it was. And so every day for like a year and a half when I was there, I had like 1 to 3 or 4 trials set. And so the days were you either try your case, you're on trial for the day, you get your cases settled, or you get your cases continued. And then you come to the office and you'll have an afternoon deposition, or you'll have an afternoon mandatory arbitration. So that's how I spent my first year of practice. Very direct training from partners who had done this longer than I've been alive, let out into the wild to try, fail, try again. You're not defined by failures. You are encouraged to overcome them and move forward. And I then left because, it's a tough lifestyle and the pay was terrible. And I went to a big firm, not a big law firm, but a big firm. And I'm handling a case. It's a very sad situation. A young boy, maybe 14, his grandmother had like a nature wildlife place out in one of the suburbs of Chicago. And they're doing construction. They're like redoing the parking lot, redoing the exterior perimeter of the place. And so there's all these fences and there's construction equipment. And of course, there are these like orange sandbags that are covering the horses. Sadly, the grandmother tripped on one of the orange sandbags, hit her head, and ultimately died. And it was a wrongful death lawsuit. And our argument, and I took the case and just ran with it because when you're working on it was like a traveler's case or one of these insurance defense $180 an hour specials, you can kind of take these and run with them with a little bit of initiative and motivation, which I had. And the theory of our case was it was an open and obvious condition. And so that was what we pleaded. That was what we established during discovery. That was the only really stuff we established. I deposed the minor grandson to establish that it was indeed open and obvious. And you just pull from, the jury instructions and then from the relevant case law talking about a factor-based test of what's open and obvious and yada, yada. And you establish through discovery that that's what this was. Got pretty heated during the deposition. The lawyer for the young man and for the family was not very happy with me. And he was saying some very, difficult things. And I had to stand up for myself, and I said some things. And I'm very proud of that because that's not an easy thing to do as a lawyer. And I bring this up because we filed a motion for summary judgment. And at the presentment out in the Collier County, I'm sitting waiting for the case to be called. And this lawyer comes in, and he's an older man with a cane and a bad knee and back and everything. Bad attitude too. Comes in, and he just took an order and gave it to me, and he said, I agree. I agree that you are entitled to summary judgment. And we entered judgment by agreement that day. And so that's really what it means to win on the papers. You win when it's easy to win. Imagine most lawyers in that situation, they would have said, well, we need discovery on her medical condition. She's got, all these medical issues, probably because she's an older woman. And, just imputing the medical health of her, the character of her. Oh, she's they would have issued discovery on her personal life. They would have wanted to, subpoena records of all this other stuff, do maybe possibly surveillance, although she had been deceased. But you understand what I'm saying. All these other tangents to go down. No, you have a path to victory, open and obvious. You focus on that path to victory. And you win on the papers.